Mr. Lynn.
Good morning. May it please the Court, Paul Lynn for the Commonwealth. With me is Assistant District Attorney Dean Mazzoni, the Chief of the Narcotics Unit of the Suffolk County DA's Office, and Assistant District Attorney Will Freeman, who is the trial prosecutor in this case. There are two disputed issues in this case. The first is whether the informant privilege applies at all, and the second issue is, if it does apply, did the defendant make an adequate showing of materiality to breach it? Judge Botsford, in her order, did not explicitly address the first issue because she found that the defendant was nonetheless entitled to the discovery he seeks pursuant to Rule 14A13, governing exculpatory evidence.
But doesn't this case end immediately because the defendant hasn't made out enough to show an entrapment defense? He never indicates the essential element that the defendant was not predisposed to commit the crime. There's nothing in his affidavit, and that's a crucial element.
Absolutely nothing, Your Honor, and that's the Commonwealth's position on
But doesn't he say that this person repeatedly and persistently encouraged or asked him to arrange drug sales?
That's exactly what he says, Your Honor. But the Commonwealth's position, and I think this is backed up by the law, especially Hodges, which we cite in our brief, that is not an adequate showing. That does not establish a prima facie case of entrapment. And the reasons for that are clear. The defendant knows exactly what Ms. Doe said to him. He was there. And under Rule 14.1b, the Commonwealth is entitled to know the statements of his witness anyway. So there's no reason whatsoever why the defendant should not be required to give a detailed showing of what Ms. Doe said to him and what his response was. Obviously, he doesn't have to do it verbatim, but he would have to at least show some substance of what this persistence and repetitiveness was.
Doesn't his own affidavit support the fact that there couldn't possibly be entrapment because Ms. Doe knew to go to him, knew, i.e., that he was a drug seller, so it was known in the community. So how could he possibly, his own affidavit indicates that there's no entrapment defense.
Yes, you're preaching to the choir, Your Honor. That's certainly the Commonwealth's position. I would like to also address the applicability of the privilege here.
Can I just ask you a little procedural thing?
Yes.
Is this here on a 211.3?
It is. It was a 211.3 that was reported to the full bench.
There's an interesting case on Thursday. You may want to be around and keep an eye on it because it raises the issue whether the Commonwealth should even be allowed to file 211.3s on evidentiary rulings like this. You familiar with what's coming up Thursday?
I'm afraid I'm not, Your Honor. I'm embarrassed to say.
Commonwealth and Kearns.
I will certainly keep an eye on it.
It asks us to reevaluate the whole situation where evidentiary rulings of various kinds, which would include this one, should even be allowed to come in under 211.3s.
Well, anticipating
but
that,
that's not brief.
At least say as a policy matter that there are compelling reasons, as this case shows, why that practice should continue. But as for whether or not the privilege applies here, it is important to realize what the defendant knows and does not know. As in Commonwealth versus Youngworth, the defendant knows the identity of a person who introduced him to the undercover trooper. What he does not know is the identity of an informant, or whether an informant even exists in this case. And that was the same distinction that the appeals court made in Youngworth. Now, the defendant's take on Youngworth is that the appeals court ruled that the judge's ruling was harmless because the defendant clearly never meant to call this witness. But that wasn't the ruling. The ruling was that the judge was correct in denying the defendant's pretrial motion for disclosure of the informant. And at the time of the motion, the judge didn't know whether or not the defendant was acting in good faith. He didn't know whether or not the defendant would try to call John Doe anyway. It was only later that that occurred. And the facts of Youngworth are essentially identical to the facts here regarding the informant privilege. The defendant knew and named a person who was named in the opinion John Doe, but there was no question that he actually named this person, and the court said later on page 36 of its opinion that he had enough information that he could have called him at trial. But nonetheless, he wanted to know whether or not this particular person was the informant that had come to the police and essentially revealed the plot to them. And the judge ruled, no, you're not entitled. That information is protected by the informant privilege.
Well, let me think about this a little differently. I take it this witness is now on his list of witnesses.
That's correct.
I assume, or maybe you would disagree with this, that as such, he's entitled to information from the government, for instance, any statements that that witness may have made to the government, yes? Durham reversed.
I had a feeling that might come up.
Yeah.
No, I think to the extent that those statements would reveal whether or not Ms. Doe was acting as a government agent, a showing of materiality sufficient to breach the informant privilege. And I also would point out a second factor. On page 8 of the defendant's brief, he points out that throughout this process, he's been seeking not only information regarding Ms. Doe, but also any connection between the government and any family members or loved ones of Ms. Doe. And he certainly has not been able to name any of those. So the informant privilege would certainly apply to that. Now, turning to the second aspect of the test, which is whether the defendant has made a sufficient showing of materiality to breach this, and I've touched on this earlier, that is, the defendant has all the information he needs to make a prima facie showing of entrapment. He was there. He knows the substance of what Ms. Doe says. He knows the substance of what he responded. So there's absolutely no reason why his failure to make a prima facie showing of entrapment in his affidavit should be excused.
So are you saying that he can develop this at trial?
The Commonwealth's position is what he could do at trial is at any point that he makes the showing of materiality, the Commonwealth would be required to divulge the information. Whether he does that, if he wants to know ahead of time, he's got to do it now. If he were to call Ms. Doe to the stand and she were to say, "You've got me, yes, I put a gun to his head," well, that's certainly a showing of materiality.
No, that's obviously not what he would do.
Mm-hmm.
I assume he would ask her, when you urged me to meet with this person, you were acting as an agent of the government. You had a deal with the government. I assume in those questions would be appropriate.
The Commonwealth's position is no, and I don't think there's any authority for that being allowed over the Commonwealth's objection,
Really?
absent a showing of materiality. Again, let's take the Commonwealth concludes its case, and of course there's no dispute whatsoever here. Ms. Doe is not a recipient witness. She didn't participate in the crime. So the Commonwealth puts on its case. There's no evidence whatsoever regarding Ms. Doe. The defendant calls his first witness as Ms. Doe. He asks her, "Isn't it true that you were persistent and repetitive in asking my client?" Now then one of two things happens. She either says, "No, I don't know what you're talking about," in which case there's still no evidence of entrapment, or she says, "Yes, there is evidence of, yes, I was persistent and repetitive. I did badger him to do this," in which case now you do have material evidence of entrapment. Or he can take the stand himself and say, "Yes, she badgered me. I didn't want to sell drugs. I never sell drugs, but I finally did it because she was a friend," or something along those lines. But until he does that, the whole issue is completely irrelevant.
You're saying it's like an academic discussion we're having, right?
I'm not sure I understand the question.
Well, that he can, I think it's been alluded to before, but that he can get everything he wants from this witness who he knows, by identity of whom he knows, by just putting her on the stand and going forward the way you're suggesting.
He certainly can do that. Obviously, what he wants to know ahead of time is whether or not she was acting as a government agent, because obviously if he calls
But he also wants to know if there were any promises, inducements, or rewards that were offered to her, too, right?
Correct. But as Judge Botsford recognized, he's not entitled to that information under Rule 14-1A9 because it's his own witness. He may be entitled to that information if he makes a showing of materiality under 1A3 regarding exculpatory evidence, because it would be material to his defense. But he's not entitled to promises, rewards, and inducements of his witness. That's the rule is crystal clear on that subject.
But you could ask her that at trial. Did the government promise you anything?
The Commonwealth's position is until he has made a showing of materiality, until he has made a prima facie case of entrapment, whether he does that now, whether he does that at trial, the issue is irrelevant. The question can be disallowed as irrelevant to the case.
Well, I was going to ask you that. If he put her on the stand and said, "Did you beseech me to make the sale?" would you object on the basis that there's no foundation for entrapment?
Oh, no, because that's how we would lay the foundation for
Well,
entrapment.
or of voir dire, unless.
That's also another way he can do it, yes.
Well, so I'm misunderstanding. Let's say he has her on the stand and says, you wanted me to meet this person to sell him drugs. It was your idea.
Yes.
All right? She goes, yes. And he can't then say, and you were working for the government at the time.
He can't ask that question until he's made a prima facie showing of entrapment.
That's quite extraordinary to me, actually.
That's the standard materiality required to breach the informant privilege. He has to prove the defense before he can ask the question?
In
order to breach the attorney-client privilege, or excuse me, not the attorney-client privilege, the informant privilege, he does. Ordinarily, of course, he doesn't have to reveal anything regarding his case.
I don't see how this falls into the informant privilege. I mean, if he establishes she is part of this transaction, she may not have been a percipient witness, but she set the transaction up, then what's the informant privilege got to do with this? It's a question of her actions in connection with these transactions. What's the informant privilege got to do with this?
The informant privilege is whether or not she was working as an agent of the government.
And doesn't that bear directly on her credibility, on her motivation, on everything that's relevant to this defense?
Once he makes a prima facie showing of entrapment, yes. Before that, no. It's completely irrelevant to the case.
The usual informant situation is where their identity isn't known.
That's true.
And that's what they're trying to find out. Here you got the identity known, but I guess you're saying she's still an informant vis-a-vis the fact, or insofar as she may be working for the police.
I think the important thing to realize is that if the informant privilege doesn't apply here simply because the defendant knows the identity of the person who introduced him to the undercover trooper, the Commonwealth essentially can never use an informant or an agent that is known to the defendant. Because
it's very rare that you would.
I would disagree, Your Honor. I think it may be very rare in the appellate law, but it's certainly not a rare situation on the street, because obviously defendants want to try to limit the scope of the exposure of their illegal activity. So they are, any prudent drug seller is not going to want to.
It just seems logical that someone who knows this kind of person, who claims that she worked on him, beseeched him, whatever words you want to use, begged him to make the drug sales, simply could not get the information that they seek here. Was she acting at the behest of the police? And if so, did they make any promises to her about doing something for her or her family? That just seems illogical not to give him that, doesn't it? I mean,
certainly,
they set up all these barriers. You got to show this, you got to show that before you do this, and I don't know.
This court has consistently affirmed the importance of informant information and the importance of being able to tell informants that you can provide us with information and your identity and your relationship with the government can remain a secret. And
well, the identity part of it's out of this case.
Well, but I question whether it is, because it's one thing the defendant says that he knows she's an informant, but the government has never acknowledged that, and I think there's a distinction, at least it seems to me, one that I'm not sure comes through the briefs, between his saying he knows it and the government acknowledging it.
Absolutely. That's the Commonwealth's position. He knows who the person is. He doesn't know who the informant is. And I think that distinction is crucial, because there is a fundamental difference for both the defendant and Ms. Doe as to whether or not she was just as duped as he was or whether she betrayed him. And that makes all the difference in the world.
Well, here's what the trial judge said. She said, I conclude that in the circumstances of this case, the requested information, if it exists, may be considered exculpatory. The defendant asserts that the individual was acting as an agent for, or at least at the direction of, the police. This assertion, if true, has a direct relationship to the entrapment defense the defendant has asserted, since entrapment focuses on, quote, evidence of inducement by a government agent or one acting at his or her direction, quote. What's wrong with that?
What's wrong is that she allowed this order based solely on the showing of the evidence being exculpatory without showing that the defendant had made an adequate showing of materiality. And the Commonwealth's position is in order to breach the informant privilege, the defendant has to make just more than the showing saying, I was entrapped. And that's all he says, really. Saying, I see my time is up. May I finish asking the question?
But this is a closer case, it strikes me. I mean, here, the judge actually, I take it at the request of the Commonwealth after she made her first ruling, actually asked for the information in camera, or said she would review it in camera.
Yes.
And then she concluded that it was exculpatory. So we give no weight to that?
You certainly give weight. She was the trial judge, but the Commonwealth's position is this is inadequate. The defendant's showing was inadequate as a matter of law.
So
and if it is not,
it may be exculpatory, but since the defendant hasn't proven it without having seen it, we're not going to give it to him.
he doesn't have to prove it. He has to make a prima facie case of it.
Well,
and I think,
But we go back to the first thing. The defendant has not made out his defense of entrapment. He hasn't shown that he wasn't predisposed to commit the crime. That is an element before you even, there isn't any entrapment in this case.
there's
as far
no,
as I can
there's
see.
there's no entrapment here. There's no showing of
So
entrapment
we shouldn't
here.
even get to all these other questions, it appears to me. Because there's no showing of entrapment, there is no showing from the defendant's affidavit. In fact, the contrary is shown. He is clearly disposed to commit the crime.
I think that's true, and I think the Fifth Circuit was wise in this case by saying that if this is enough to breach the informant privilege, then the informant privilege at trial goes out the window. It is defenestrated.
Thank you.
Thank you.
Mr. Coviello? Maybe you ought to begin with Judge Cowan's point. What has he shown about entrapment here? What has he shown that even gives a scintilla of a hint about entrapment?
Well, what Judge Botsford requested was, and the record is clear on this, is that the defense provide, quote, basic information, end quote, so that she could make a discovery determination concerning pretrial motions, which I filed in order to get this discovery issue and other related issues to the court well in advance of trial.
But in your affidavit, in order to get to breach the informant privilege, you have to show some evidence of entrapment, and you haven't done that. Regardless of what she asked you for. In any case where you want the privilege breached, you have to make some showing, enough to make out at least the elements of an entrapment defense, and you haven't done that.
That assumes, which I disagree most respectfully with Judge Cowan, that the informant's privilege applied here and then needed to be breached.
Why doesn't it apply here?
Well, this case is about the order of a Superior Court judge on a discovery matter. The informant's privilege, with all due respect, does not apply to this case. That applies to the identity of a so-called informant.
But you don't know that she's an informant. You surmise she's an informant. The government has never acknowledged that she is.
The government won't tell me. I surmise. What I can say is what I said in the affidavit, which was requested by Judge Botsford, that Jane Doe is the introducing agent. Now, whether or not she's an unwitting intermediary or an agent of the government working at their behest and being supplied promised rewards and inducements, I'm not in a position to say. I could never say that. But what I can say is that the affidavit was essential, in Judge Botsford's mind, in order for her to make a pretrial discovery order.
But how can you show that? You've shown just the opposite. You've shown that your defendant was predisposed to commit this crime. And the defense of entrapment does not lie when the defendant is predisposed to commit the crime.
Well, ultimately,
I mean,
entrapment...
it's not admissible at trial, period, if your defendant is predisposed to commit the crime.
Well, but that's... We have to get to that point first by showing whether or not some evidence that there was inducement, and in fact...
But there can't be inducement if your man is predisposed to commit the crime, and your affidavit shows that he was a known drug seller in the community. Therefore, he's predisposed to commit the crime.
I don't think that's as fair
Well, how did
an
Jane Doe get
inference.
to him? How did Jane Doe get to him otherwise?
Well, you know, I certainly would ask Jane Doe that, but I'm a little bit not in a position to do that because obviously we haven't had the trial yet.
Well, somebody
and I
wouldn't come
suppose-
up to you and ask them to sell drugs, I would assume.
I would assume that.
Okay, so, but Jane Doe went up to this fellow and asked him to sell her drugs. So she must have been pretty well known that he was a person who would sell drugs.
Well, I certainly am not going to agree with that, and Jane Doe will have to answer to that when she gets called. But this affidavit...
Okay, that's my next question. Can't you get what you want? You've subpoenaed her for trial. Why can't you get the information you want from her at trial? You can ask her whether she was a government agent, and you can show her motive and bias to commit the crime.
Well, in order to wait until trial would seem to me to fly in the face of the Durham decision some 18 months ago, where there's an interest in the free flow of discovery and having not discovery trickle out during the course of a trial or discovery by piecemeal, which would be the import and the conclusion of what the court has most respectfully suggested in this case. The defendant is entitled to prepare properly his case and to present all proofs favorable, not to ask a question, turn to the government, get the piece of discovery, sort of synthesize it as I'm asking questions on my feet. That affidavit, let me get back to the affidavit if I could for a second, was merely to make sure that, in fact, the person that we had suggested, Jane Doe, was involved in this. It was not made out at Judge Botsford's request to satisfy an evidentiary threshold that would require a jury instruction or make a prima facie case. She wanted good faith shown by the defense. The defense showed good faith that this is the person who introduced Mr. Madigan to the entrapping or to the undercover
Mr.
agent at that
Coviello,
time.
let me ask you this. You say this is not about the informant's privilege, it's about a trial judge's pretrial discovery order?
That's right, Judge Allen.
And so what are we looking at? Whether there was an abuse of discretion? Was there a clear error of law? Well, what are we supposed to focus on?
Well, what I would focus on are the three separate rulings that she made which favor the defense and give deference to those determinations. Not only did she make the determination that, in fact, the defense was entitled to this evidence based on the filing of the motion, she made a margin order originally, a conditional, what I've characterized as a conditional order, obligating the government to provide him with this information. And after that, she generated a memorandum in order. The government sought reconsideration, and then she viewed, as this court has access to, the promissory rewards and inducements and other information.
You say that it doesn't involve the informant's privilege.
That's
what
right.
does it take to get the informant's privilege into the case? Does the Commonwealth have to have first provided some discovery or at least make some assertion that there is an informant involved and we're not going to disclose the identity?
Well, the government won't say whether she's an informant or not, but at this point,
We won't say whether who's an informant.
Jane Doe.
Well,
Won't say she's an agent or not, too, which may be
Okay.
critical in establishing the defense.
The type of, I understand what you're asking for, and you want it beforehand, and I understand why you want it beforehand. It is easier, obviously, when you have the discovery. But what you're asking, wouldn't it apply, take the Bishop Fuller Dwyer context? The same reasoning would apply that you should be able to find out from the complainant ahead of time whether she was treated for mental health problems. Same theory, because you don't want to wait till she's on the stand at trial.
That's
and
correct.
ask her. So that you would apply. The analogy is really pretty close.
Well, what I would say is that, particularly with the recent Dwyer case, is that there's no substitute, with all due respect, for the advocate's eye with regard to records in the Dwyer case, or in this case, what has been impounded. The government knows what's there. The court has access to it. I'm the only one who hasn't seen it. And I know what the defense is going to be. I know what the defense's
What's the
evidence is
defense going to be?
It'll be entrapment. I mean, I've provided notice. I've been upfront about it since requested. I then filed a discovery motion along those lines. But to get to the point about the
But
informers...
the minute, if Jane Doe gets on the stand and says, I went to him because he sold me drugs before I asked him to provide drugs to my friend, which I think is about said in the affidavit, that ends your entrapment defense.
No.
It would seem to me the judge wouldn't even have to let you put in evidence of entrapment.
No, with all
Because if
due...
she's been to him before and brought drugs, and bought drugs for him,
If believed, but what we're getting to here is essentially sort of trying the case here before the court and on the
but
pleadings.
I think
So
your
what-
affidavit says that she bought and did drugs with this guy. That's your own
So
affidavit.
your defense is going to be that he never sold drugs to her before?
My
and-
defense is going to be that she ensnared and entrapped him because she was working at the behest of the government.
Is he going to concede he sold drugs to her before? Or
I
is he
don't-
going to say,
I-
I never sold drugs to her before, and I got entrapped? I wouldn't have sold them to her unless she kept harping on me and so on.
Well, what we plan on showing is, in fact, that she induced him in order to sell drugs to the undercover state trooper.
Well, I agree, but going back to the point that was just made, she says she dealt with him before, the sales that are apparently an issue in this case.
Well,
Am I
it-
getting that right, or am I getting it wrong, or what am I doing? Well, think about it.
Well, looking at the affidavit, it says that she appeared wanting to do and purchase drugs.
Right.
The
She had done it.
affidavit doesn't support necessarily the claim
It
that...
says in paragraph 2, prior to the introduction, Jane Doe contacted me by appearing at my home wanting to do and purchase drugs.
That's right,
So
prior
that's
to...
before.
That's
But
before
af- So she comes up to this guy already wanting to do and purchase drugs. Then later, it says, after this initial appearance at my home, Jane Doe again appeared at my home, again wanting to do and to purchase drugs.
That's correct.
He does everything but admit that he sold them. He can't do that because he would incriminate himself terribly. And then he says at one point, she brought she came in and introduced the undercover state trooper. So he's already, to me, by paragraph 2, he's defeated his entrapment defense.
Oh, with all due respect, Judge, I mean, we're overlooking the fact, too, I would suggest that the threshold for showing inducement is low, is recently decided by the Court of Appeals a couple days before Christmas in the Doyle case, 67 Mass Appeals Court. So, with all due respect, it doesn't say what I think the Court may have thought it said with regard to prior seals. She's not subject to the informant privilege because we know the identity. She's a fact witness. And
Well, you think that she's the informant.
I think she is.
You don't know that she is.
No, nor did the defendant in Youngworth. And what the appeals court said, and what I think is supported by the McMillan case as well, is that could have called her and asked her. And that's exactly what we proposed to do. That's why we subpoenaed her. At trial.
But the Commonwealth isn't saying that there was no informant involved in this case. They're just not willing to, they're not going to say that it's Jane Doe.
That's, as I understand their position, correct.
So they have invoked an informant privilege.
Well, they have in their brief. What they're saying is that if they provide any information about promissory rewards and inducements, which, by the way, would show, in fact, the indebtedness she has to the state police and Revere police.
But they haven't said that there's no informant in this case.
No, they've played it very coyly.
Well, but they could have made this whole thing go away simply by saying that there is no informant.
They could have done that.
They could have done that. So it seems to me they're acknowledging that there is an informant involved in this case. They're just not going to tell you who it is.
And you know, is it inferable from the fact that they made a submission consistent with the discovery motions that, in fact, promissory rewards and inducements were made to her? I think it's fairly inferable as well. But that affidavit, again, was not meant to make a prima facie showing. With all due respect, it was allowed
They
Judge
said
Boston.
promises, rewards, and inducements were made to her? They've said that?
They filed with Judge Botsford, who viewed in camera, and again, had the same ruling that she did prior to, based on the pleadings, about what I was entitled to. And their submission, which is before the court, details in 2 pages, from what I can understand, their response to her order saying, supply Coviola with this information.
Okay.
And your thinking is that if there weren't rewards, inducements, or promises after she did the in-camera inspection, she would have just dismissed it.
One would assume that. That's exactly right. And she's been consistent throughout. I mean, she's understood that Rule 14, which applies to potentially exculpatory evidence, was what motivated her to rule twice before reviewing in camera the government submission. It merely confirmed that which she had ruled before and ordered them to turn it over. With regard to each and every time that the issue was broached, she decided that, in fact, we're entitled to the promissory rewards and inducements. But getting back to the government's position with regard to this, it says in its brief, pages 15 and 16, that I could call Jane Doe and I could ask her relevant questions, but I can't ask her questions, apparently, concerning whether or not she had cooperated with the police unless I show materiality. Materiality is essentially the standard. It's a Brady standard. It's generally post-conviction, not pretrial discovery. That's not the standard here that one would have to show under these circumstances here with regard to my having access to whether she cooperated or not. But if you carry their logic and apply it to the trial setting, what would a trial look like? Apparently, I'd be able to ask her whether or not she was present with Mr. Madigan, what she said, what she did, how she induced him, did she coerce him, etc., how many times she met with him. But once I get to the point of whether or not she was motivated by the government, by giving promised rewards and inducements to her, family members, loved ones, brothers, sisters, as the case may be, whatever's in that submission that I haven't seen, then I have to stop. And a trial jury, whose primary function is to seek the truth, is then presented with, if you credit the government and apply its rulings or its analysis to this case, with a twisted, warped, and really excised presentation of evidence.
But isn't it probably going to be done at a voir dire? Isn't this, there's probably going to be a voir dire on this witness. I take it. And when the Commonwealth gets up to question the witness at a voir dire, they're going to say, have you ever bought drugs from him in the past?
They may, but you know,
Well, they're going to, unless they're fools, but they're going to do it. And if she says yes, the witness isn't going to testify unless she testifies for the Commonwealth.
Well, she may say whatever she wants to, and that's, you know, subject to dispute at trial. But, you know, these issues need to be heard before the jury, so they can decide the issues of credibility. You know, is there going to be some evidence of predisposition? Mr. Lynn and his attorneys would say yes, but in fact, that doesn't mean it has to be bought by the jury. These issues, you know, entrapment's a jury issue. We don't tolerate a trial by police report, trial by pleading.
But haven't our cases said that, maybe I'm wrong, that before you can put forth a defense of entrapment, you have to make some showing of the elements sufficient to at least enable you to ask the questions? You just can't get up and say I was entrapped.
At trial, sure, and he can show inducement at trial. And whether or not
So based on the questions Justice Spina just asked you, just said would be asked by the government in a voir dire, you wouldn't be able to present the defense of entrapment.
No, I believe with all due respect we're going to, but
How could you be allowed to if in a voir dire of the Jane Doe she says I've been buying drugs from him and doing drugs with him for a couple of months, couple of years, whatever?
that would then make the whole entrapment issue a jury question at the least. It wouldn't knock him out of the box in terms of whether or not he's entitled to an instruction on it. If there's inducement, he gets an instruction.
I'm not certain about that.
Why would it make it a jury issue if he sold drugs to her before? Is he going to say, well, geez, if I had known she was a government agent, I wouldn't have sold drugs to her?
Well,
everybody's going to say that.
You know, we're going to be able to present an entrapment defense, and with all due respect, and whether or not, you know, there are some prior sales. The case law seems to be clear that there are some prior sales, but that question still goes to the jury.
The jury could find that, sure, he's a drug dealer, but, you know, he might not have made sales to her, so for whatever reason, apart from government agent, so he was entrapped as to those sales, even though he is a drug dealer.
And they have to prove predisposition beyond a reasonable doubt once inducement is shown.
I would imagine you could have a scenario where you had someone who at one time in their life had sold drugs but had decided they were out of the trade, and then someone came to them and pleaded with them to do it for me.
Right.
I would imagine.
But that isn't this case, because in this case, the defendant says in paragraph 2 that they had been, that she had come to him this summer. Well, no, it doesn't say precisely when, but the implication is that it's during the relevant time.
I see I have no more time, but I do think the court is
I think we know what we're...
generous inference in that.
Yeah, thank you.
Thanks.
I think we'll take a short recess.